students, academics, journalists, ladies and gentlemen who have logged in today. Today's discourse is titled From Courtroom to Newsroom Protecting Rights Amid Media Trials. We are indeed living in a time when administration of justice is no longer confined to the four walls of courtroom. Judicial proceedings today unfold parallel in the public sphere through newsrooms, digital platforms, and social media, where narratives are formed, opinions are shaped, and verdicts are often anticipated long before court pronounces its judgment. It is indeed a delicate balance and complex balance between transparency and fairness, between public interest and individual rights, that forms the foundation of today's discourse. It is a great honor today to have with us two eminent personalities of the Indian judiciary. Honorable Shri.Justice Jasti Chelameswar, former Judge, Supreme Court of India, and Honorable Dr. Justice A.K. Jaysankaran Nambiar, sir, Judge, High Court of Kerala, and the Executive Chairman of ILI Kerala State Unit. Before I invite Honorable Dr. Justice A.K. Jaysankaran Nambiar, sir, for the introductory address, allow me the privilege of introducing His Lordship, who truly needs no formal introduction. Designated as senior advocate in 2011 and thereafter elevated to the bench in 2014, His Lordship is widely renowned for his clarity of thought and analytical depth. His Lordship's principled approach, especially while heading the constitutional bench in the case of Dijo Karpan, has become cornerstone in contemporary discourse on press freedom and constitutional protections, making his presence especially meaningful in today's discussion. It is truly an honor to invite Honorable Dr. Justice A.K. Jaysankaran Nambiar, sir, to deliver the introductory address. Sir.
Good evening, all. As the Executive Chairman of the Kerala chapter of the Indian Law Institute, it is indeed my pleasure to welcome you all to yet another interesting talk, or this time on the topic From Courtroom to Newsroom, Protecting Rights Amid Media Trials. As we all know, in a democratic republic governed by the rule of law, free speech plays a very important role and a crucial role. It is that singular factor that ensures healthy debates and discussions on almost all matters of governance and creates within the civil society a true marketplace of ideas. Fostering such spaces in society ensures development progress of a nation, and it is therefore that under our constitution, the right to free speech is zealously guarded, and any infringement of the right viewed seriously by our constitutional courts. Axiomatically, this means that the freedom of press is also protected against arbitrary and unreasonable curtailment. But the question that is often asked is, what are the limits, if any, to this right of freedom? Now, as we all know, that the concept of an absolute liberty is anathema to any society that claims to be democratic in matters of governance. There must always be an element of give and take when it comes to understanding the scope of one's rights and duties, and this must necessarily apply to the media as well. Which brings us directly into this question as to what is responsible journalism. According to me, responsible journalism comes with an understanding, the basic understanding, that there is no such thing in this world as an absolute truth. Everything that you see is a perspective, everything that you hear is an opinion. Given then that there is an element of subjectivity in a journalist's reporting of facts, the question that is often asked is how much of that subjectivity is acceptable in ethical journalism? And at what stage does journalism cross the dividing line between reporting and indoctrination? To take us to to talk to us now on this important theme of contemporary relevance, we have probably the best person with us in Justice Jasti Chelameswar, former judge of the Supreme Court of India. A warm welcome to you, sir, and we look forward to your address. Over to you, sir.
Thank you, brother. I was only waiting for somebody to mention I was also the former Chief Justice of Kerala, but nobody mentioned. Everybody remembers me as a former judge of the Supreme Court. I think God's own country has forgotten me, perhaps. Anyway,
No, we will never forget you.
no. Don't take it too serious. Anyway, good evening to all of you. I'm grateful for this opportunity to interact with the people of Kerala once again. Of course, it's live streaming. Obviously, perhaps the whole nation technically would be accessing it, but then primarily it is meant for the Malayali society. Now, courtroom to newsroom. Very rhythmic caption. I would say, newsroom apart, analysis or criticism of judgments is nothing new to Indian judiciary. Let's confine ourselves to the Indian judiciary. Olden days also, starting from the street corners to the editorial columns of the newspapers, there used to be some debate and discussion about judgments of the court. Not every judgment, but some of those prominent cases, prominent, notorious, or whatever tag you give it. People used to discuss in the street corners. I know, a matter like this, everybody will not discuss. The participants would be very limited. Editorials obviously were not written by every journalist. A very senior journalist, trained and with some standing, used to write the editorials, critically analyzing some of those important judgments of the time. And I still remember, by the time I entered the profession, it was the height of emergency in 1976. Even in those days, at least bar associations, people used to discuss the legality of ADM Jabalpur and so on and so forth, just to give one example. This kind of a discussion was never absent. But what happened of late is this. The advent of digital media, TV, and then later the internet, and coupled with the liberalization of the state policies, which ceded space to private players in the media. See, at least till 1982 in Hyderabad, there was no TV at all. The first TV broadcast in Hyderabad started in 1982 December. And then it was a state-controlled TV. They only projected whatever the government wanted them to project. Now, post-90, after the liberalization, private players enter this area. Along with the entry of private players, certain other incidental factors come into play. Basically, these are all profit motivated organizations. None of these private TV channels is running a charity there, barring a few politically affiliated to some political party, in which case they have their own way of looking at things depending upon their own political philosophy. Rest of the private channels, their main driving force is to make profit. And then in the process, they need to grab as much of viewership as possible. Now, necessarily goes with it sensationalizing events and news. All these things play a role in this. And necessarily, for a period of time, people's interest in the court proceedings also increased from time to time for various reasons. In my opinion, so long as the judicial system confined itself to the adjudication of private disputes and interpretation of law, even in some areas, if it is not so private in the sense when there is a litigation between the state and a citizen, which pertain to the interpretation of law or the constitution. Law includes constitution, interpretation of law. The scope of the debate about the legal proceedings was limited in the sense it is more perhaps a jurisprudential debate. For good or bad, the Indian judiciary developed the concept of public interest litigation, which triggered off various other things. The minute we talk about a public interest litigation, all my friends who are in the meeting or who are following us obviously know, belonging to the legal fraternity. What started as a tool for helping people without necessary resources and adequate access to the legal system, that was the purpose of the public interest litigation, starting from either Bandhwa Mukti Morcha or County Municipality, whatever cases. Of course, I don't want to go into the case law now. The origin of public interest litigation. But then over a period of time, public interest litigation expanded, the scope of the public interest litigation expanded beyond all comprehension. And slowly with it, politics crept into judicial process. Of course, I may sound a little prejudiced because if I quote an example from my own parent High Court, in my view, the mother of all this political interest litigation was something which started in 1987 in Andhra Pradesh, old Andhra Pradesh High Court. Late Mr. N.T. Rama Rao, who was the chief minister, the party opposing him engineered a public interest litigation making innumerable allegations. Some 205 allegations, if I remember right, were made in that writ petition. Mostly based on newspaper items, so on and so forth. I don't want to go into the details of the case. And the court hall became a political arena. All kinds of arguments and all kinds of charges were traded in that matter. Now, since we are talking about courtroom to newsroom, the only available TV channel that time was Doordarshan. For the next 3 months, it went on, publishing news about this particular case. Necessarily not very favorable to the chief minister, because it was controlled by a government which was adversarial to him. Well, anyway, it had its own, unfortunately, High Court recorded certain findings, the correctness of which was challenged before the Supreme Court. By the time the Supreme Court could decide the matter, that gentleman died, therefore the court held it as infructuous. Nothing decided was decided, but the damage was done. The man lost the next election. And this campaign really did some damage to him. I'm not saying whether he is right or wrong. I'm not at all on that. We're talking about the media and its this thing. And this became, in my view, the starting point of all kinds of political litigation, and then use of media for advancing political agenda of various people, sometimes even private agendas. Now, question is, when the judiciary was limiting itself to the questions of interpretation of law, statutory law or a constitution. The debate is a very limited debate. The moment court starts dealing with matters which, in my view, at least some of the matters, are not strictly justiciable. Well, the distinction between justiciability and non-justiciability seems to have been totally eroded. Anything, if I have some complaint against somebody, I can go to the court. Whether court is the right place to deal with this problem or not, nobody is asking. In fact, I remember still one of my former Chief Justices when I was young in the Andhra Pradesh High Court, late Justice Ramchandra, who's my idol as a judge. Sitting in the writ admission court, the first question he used to say, please read the prayer. Then after the prayer is read out, then the next question is, please tell me what is your legal right to this relief. I hardly see any learned judge nowadays asking this question between the right and relief. There doesn't appear to be any correlation nowadays. Nobody asks that. Not many people. I'm sorry. I'm sorry, I can't generalize, but not many people do ask this question. Now, the result is with this kind of litigation, where views are subjective. Well, of course, I think it is a pending case. I don't know how right it is to debate, but just as an example, I'll tell you. I noticed on the media the other day, Supreme Court passed an order about stray dog menace in the Delhi city. But it's a menace. Essentially, whose problem is it? It's the problem of the state, and state has to take care of all these things. Now, the immediate answer, legal answer from the days of Justice Iyer is the state is not discharging its function. Therefore, we as guardians of the Constitution compel this. Wonderful. Logically, it is an excellent argument. But the point is it a judicially manageable thing? Suppose the man on the sanitary inspector of the Delhi municipality or whoever is responsible for dealing with this stray dog. All of us know all municipal acts provide some system for dealing with this problem, every state. And if the man doesn't deal, okay, at the highest court level, if you start interfering, well, the pain of incurring some displeasure from my colleagues sitting in the Supreme Court today, tomorrow if the dog doesn't disappear, what is the Supreme Court going to do? For that matter, any court, High Court. No, these are all areas, but are they judicially manageable or not? Is a question which I have my own doubts of. I may be wrong. At least I'm a Democrat. I don't mind conceding that in a given case I can be wrong, but then I'm expressing my views. Now, when this kind of an activity starts, now the other day I noticed here, I don't know about Kerala. Nowadays in Telugu cinema, when a cinema is released on the first few days, the tickets sell at an astronomical rate. And then some time back, somebody went to the court saying that you restrict that the cinema walas can't collect this. It all sounds very wonderful. See, the ticket is being sold at 3,000. There's a huge debate on the Telugu TV for a week, full-time debate on these things. Now, there are views and views. Somebody says, well, I have spent 500 crores for making this movie. Who are you to tell me that I should not sell my ticket? It's the market. And somebody who is holding a very responsible position and who belong to that field says, who are you to tell? We have invested money. Now, these are all larger philosophical questions. Question is whether the court should get into these areas. If they get into the areas, where do you draw the line? Well, and then these questions are bound to generate public debate. And especially when you're talking about the cinema, today the whole Indian society, the major activity is watching movies and debating about movies. Now, why will they not discuss it? And how many people can be controlled? Now, second thing is the free available. Now, internet is one more thing. But I remember long back, as a student, I was reading early 20th century, First World War and Second World War. The first act of occupying army of a foreign territory is to capture the radio station to control the dissemination of information. TV almost made it irrelevant because in fact, I'm sure some of you must be remembering it. In 1990, post the Berlin Wall collapse, the Time magazine ran a series of articles about the developments in Europe and Russia and so on and so forth, what all went on. I remember distinctly one of the reasons given by the Time magazine those days in the analysis, why did the Eastern German people react so strongly? Because the younger generation of Eastern Germany had the advantage, or the governments of Eastern Germany had the disadvantage of the TV communication from the other side of the wall, which can't be stopped. Now, the younger generation noticed the kind of freedom the people in Western Germany were enjoying, youngsters were enjoying. So there was a strong motivating force for these people to go and break the wall. No, so what I'm saying is technology has its own role in each one of these things. Today, if we have this mobile phone, smartphone, not necessarily Apple phone, any smartphone in your hand, you can put your ideas to the whole world in seconds. You put it on the YouTube, you put it on the WhatsApp, the next minute the whole world knows what your views are. Your views may be right, wrong, justified, unjustified, stupid, brilliant, whatever it is. That's the thing, but the whole world knows your views. It's a fact. And in a democratic society, of course, we have been watching of late occasionally governments disable the internet services in certain parts of the country for various XYZ reasons. All of us have known that. I think latest also, yesterday I saw somewhere internet services were stopped, I think, parts of Bengal or someplace. I don't remember exactly, but somewhere. No, but then stopping, is a democratic country prepared, or would it be right constitutionally to totally disable these services? Well, I don't know what Jayashankar. I'm a man of the past. You have the authority today. You better decide it for yourself whether such a embargo can be. Now, the fact remains, it stares us. Internet stares at us. The minute it is there, okay, you control, you make a law dealing with the TV station debates. We may think of, if at all, may think of banning. No pending case shall be discussed in the. It's possible, okay, in TV you can control because somebody can. Now, how do we control this internet? Anybody with a smartphone can put his views and then they go viral. The way things are. In fact, talking about TV shows and the newsroom, I may be permitted to read a small message which I received about a year back. Just 1 second. Give me a second. I saved it carefully. With the permission of the gathering, I'll read out this message. I preserved it. In 2000, terrorists attacked the 7th Raj Rif unit stationed within the Red Fort premises, resulting in the deaths of 3 soldiers. Muhammad Arif, the main culprit, was arrested by Delhi police 4 days later. Now see the beauty of Indian justice system. Mind you, my dear friends, I have not generated this. I received it from somebody. Indian justice system. The trial court took 5 years to sentence him to death, 2005. Delhi High Court took another 2 years to confirm the trial court's order, 2007. Thereafter, the Supreme Court took 4 more years to maintain the same order in 2011, and another year to reject the review petition, 2012. Then 2 more years to reject the curative petition, 2014. In September 14, a constitutional bench of the Supreme Court ruled that in all cases in which death sentence was awarded by the High Court, such matters should be listed before a bench of 3 judges. Thus, Arif once again became eligible for a rehearing of the review petition which he filed Another 8 years later, the Supreme Court rejected his review petition 22. Then Arif filed a mercy petition, which was rejected today by the president. 24 years after killing 3 of our soldiers and waging war against India, Arif is still alive and living on taxpayers' money. Just wow. This is the message. Some friend forwarded it to me. I simply sent it. Wrong number. I was a dissenting judge in Arif's case, constitution bench matter. That's my only defense. But the point is this message. Now, how can you stop this? Now, one thing is systems problems. Whether it was really, well, of course, I don't want to comment on Arif's judgment because I was a party to it and as a dissenting judge, it's not right for me to do this thing. But then this is what ultimately is going. This kind of a debate goes on. So long as internet is there, I don't think even to trace out who sent this message would be a Herculean task. Where it originated? So who sent it to me? I know. A good friend of mine sent it to me, and he must have got it from some other friend. Some other friend got it. Where it originated, God knows. When it requires a huge effort to win, and this kind of discussion on internet is something which can be handled. In my personal opinion, contempt is no answer to this. Contempt is no answer to this. For various reasons. One is not practicable. Second thing is it would simply be suppression of free speech. Remember that famous statement of Winston Churchill. Maybe the generation of Indians hated him. That's a different story. On some occasion, he said, where there is a great deal of free speech, there is bound to be a certain amount of foolish speech, he said. That's the truth. It is going to be there. People talk, all kinds of people, illiterate people, semi-literate people, people formally literate, but, and all kinds of shades of things. Opinions are generated. Now, the only, insofar as the legal system is concerned, my own belief is that we improve the quality of our adjudication. I'm sorry to say this, I said it more than once, even sitting on the bench. Once in a way, we come across some orders of the constitutional courts, both Supreme Court and High Courts. After deciding a case, a caveat is added. However, this shall not be a precedent, shall not be treated as a precedent. In my view, it's a plain confession that we have not decided the case in accordance with any principle known to jurisprudence. Otherwise, why would it not be a precedent? It's a simple confession. And naturally, these kind of exercises are bound to attract adverse criticism. And I tell you a hilarious episode, my personal experience. 1983, general election took place in Andhra Pradesh. That Mr. Introductory became the chief minister. An election petition was filed challenging his election on XYZ grounds. One of the grounds is he made a religious appeal, a corrupt practice under 123 of the RP Act. What was the religious appeal? Somebody, see, he acted in a lot of movies, played the role of Lord Krishna, and I think 27 movies he played that role. So he was very popular for that role. So some enthusiastic fellows printed those posters and Mr. Introductory attired as Lord Krishna and then pasted all over the state. The allegation is this amounts to religious appeal. Anyway, that question never came to be decided finally by any court in this country, but number of election petitions came to be filed. It went on like that. Forget it. Now, in this particular case, Mr. Ramarav's case, I was the junior advocate on record in that matter. So naturally, it was a challenge of a 7-year-old lawyer. Chief Minister's case is a great challenge and then an opportunity in the profession. The whole summer I sat down and read every reported judgment of the Supreme Court on Representation of People Act. Just then, the latest judgment at that point of time was Karunanidhi versus Hon'ble, 1983 Supreme Court. If I remember right, page number is 95 or 85, or 1983. The issue there is Section 82 or 83 of the representative. My memory is failing with reference to numbers, which says An election petition shall be filed with as many true copies as there are respondents. In substance, that's what the section says. The question is, what is a true copy? If an election petition contains certain annexures, the copy is served on the respondent does not carry with it the annexures, would it be a proper presentation or not is the question. In Karunanidhi's case, the Supreme Court said it's no proper presentation. The election petition must be rejected in limine because there is no proper presentation. He was right or wrong, it's a different matter. You can have it, but that's the judgment of the Supreme Court. We are bound by it. In January, we were bound by it. In the same year, September month, another case, this went from old Andhra Pradesh state, present Telangana. A gentleman called Mr. Madan Mohan, who was a minister for some time and all, his election was challenged. There also a similar objection was raised, annexures were not. Supreme Court decided something almost diametrically contrary to what the Karunanidhi's case decided. And I'm making this statement with some responsibility. You can read those judgments. Now, in the whole process, this election petition got adjourned for almost a couple of years for the reason event happened very fast in Andhra Pradesh those days. India's government was pulled down, somebody became the chief minister for a month, and then he came back to power. Then Mrs. Gandhi was assassinated, Lok Sabha was all these events. This election petition got somehow, nobody was either the winning party nor the challenging party was interested in it. So finally, after 1985, then the late Mr. Rentana wrote dissolve after becoming the national opposition in 1984 Lok Sabha election. He dissolved the assembly and then called a fresh mandate. Then after that, the matter got listed before a judge called Justice Raghuveer, who was one of my grand predecessors in Guwahati. And Justice Raghuveer said, anyway, I don't want to trouble you with the full details, but eventually he ordered notice to the Attorney General. Much later, maybe after the gentleman, Mr. Parasaran, was too busy those days with some the Bhopal gas or something like that. He took 2-3 adjournments and finally he came. In fact, when this question raised was, in view of the dissolution of the assembly, whether the election petition should be tried. There's a question raised by the court, not by me. I conceded there is an allegation of corrupt practice. You will have to try it because if it's proved, irrespective of the fact that the assembly is dissolved, the man is liable for it's against the interests of my client. Still, I conceded because there's a legal position. Then the judge said, Chelameswar, you were right normally. Prior to Mrs. Gandhi's election case, 6 years disqualification was automatic. Now it is not automatic. It is the discretion of the election commission, the president and election commission. It's not an automatic disqualification. I have my own doubts. I'll order a notice to the Attorney General. I said, please go ahead. Who am I to stop? My client is sitting in the Chief Minister's office. Now Mr. Parasaran came. Initially, the man was a little, I know, he said, it's a settled legal position. I don't know how. Then judge told him, look here, Mr. Parasaran, your opponent was more than fair. He didn't raise it. I am raising this question. Then he cooled down. Then he said, you have no choice but to hear the matter and decide the matter. When the answer is given, Justice Raghuveer asked, incidentally, Mr. Parasaran, I have one more question. And then any lawyer and Parasaran, very diplomatic senior head, my lord, I'm at your lordship's service. And I said, look here, 83, same year, there are 2 judgments of 2 judge benches, diametrically contradictory to each other. What am I supposed to do sitting in the High Court on the face of this legal position? And please hold your words, my dear friends. Mr. Parasaran gave a devastating answer that day. I still remember 40 years later. He told the court, your lordships are lucky. There are 2 judgments before your lordships. Your lordship may choose whatever appeals to your lordship's conscience. Nowadays in the Supreme Court, I am confronted with a situation. I rely on the earlier part of a judgment and my opponent relies on the later part of the same judgment. He said it in the court. I was a witness. Ms. Parasaran is of course there, very old, but I don't know whether he still remembers it or not. The judge is no more. And I don't get anything by telling you a lie today. Well, with this kind of a situation, to tell people don't debate judgments at all is no option. What is right for the Attorney General in the court hall can't be wrong for a citizen, ultimately, who makes it possible for all of us to occupy these public positions. You can't tell him that you can't talk about it, only Attorney General can talk or judges can talk about it. No. Whether it should be a civilized talk, whether it should be a structured talk or not is a question. But then I told you, sometime back I was reading that book by Mr. Farid Zakaria, The Future of Freedom. He says in olden days, the credentials of artists believed on who admired the artist. Subbalakshmi, late Miss Subbalakshmi, a great artist, and then, but who are those people who admired her? Those who had some introduction to Carnatic music, who knew how to enjoy that system. Now, later, now the film songs, second day, perhaps 2 days later, they'll be forgotten. But then millions of people watch. So Zakaria says, question nowadays is not who admired the artist. How many people admired the artist is a question. And this is what he says is democratization of the whole process in the literal sense of it. More people participate. The advent of internet democratized the whole thing. It's open. There is no point in complaining about it. You must learn how to handle it. Maybe the only thing, if it all starts with our own institution, we should be more alert about it. No, notwithstanding the fact that in spite of our best efforts and very good adjudicatory process, there will always be people who are willing to find fault with adjudication, because in human sciences there is nothing perfect about it. Views which were held, Golaknath case those days, 1967, a lot of people said wonderful, a lot of people criticized it. And then came Keshavanand, that is 6 years later, they said it's bad law. So therefore, there's nothing absolute about these things. So long as people don't cross the limits of decency and the permissible limits of debate in public on public issues, I don't think we should really grumble. Perhaps the only thing we can do is try to constantly improve the quality of the judicial process, which is in the hands of all of us. It's not only in the hands of judges, the members of the bar, judges. And, to some extent, the civil society's responsibility of not encouraging uncalled for comments. What is most troubling? See, I have no problem about somebody criticizing any judgment for the legal correctness of it. The famous saying is, well, facts are sacred, opinion is free. So long as people don't distort the facts, any opinion is possible, provided it is expressed in a way which is in a parliamentary language. In fact, some of you may recall, if you have not already seen it, after Senior Bush got elected, there was an election petition. Al Gore was the contesting candidate. Gore challenged the election. The matter went up to Supreme Court, and eventually Supreme Court held in favor of Bush. The amount of criticism that judgment attracted, I don't know how many of you remember that. Almost a library full of material was published criticizing the court, supporting and mostly criticizing the correctness of the judgment. And one of those scholars from Harvard, Alan Dershowitz, he wrote a book, which if the title, if I mention today in India, well, I don't know what's going to happen, but anyway, it's a published book in circulation. Title is Supreme Injustice. That is the title of the book, Dershowitz's book. He literally tore the judgment to pieces. One profound statement I still remember from this book. He said, a nation whose highest court can't be trusted in testing times is a nation whose way is surely paved for dictatorship, he wrote. But I don't think there can be any more harsher criticism over the institution or judgment. But then the American society accepted all these things and went along with it. Now, there's nothing absolute about it. I'm very fond of repeatedly quoting that. In fact, I quoted in my NJSA judgment. Lawrence Tribe, in his treatise on American constitutional law, he says, I do not consider the judgments of the Supreme Court to be synonymous with constitutional truth. A court which held slaves to be non-persons, Dred Scott. Separate is equal, Mazavas Ferguson. And one more case he mentions, I forgot, says could either hardly be final or infallible. But then the profundity of the man's scholarship comes in the next sentence. Such passing finality as the judgments of the Supreme Court have, mark the word, such passing finality, is essentially a compromise between order and chaos. I suppose that is the gist of all democratic debate, insofar as any debate, and more particularly in the context of judicial proceedings. We accept the finality of a judgment. We may not agree with it, but we have our right to discuss it, debate it, and even perhaps condemn the judgment, saying that it's a wrong judgment. That's why I quoted the. In fact, a little aside, a personal experience when I was in Guwahati. On some occasion, the then Vice President of India was in Guwahati, some state-sponsored program. A formal dinner was organized. Naturally, as Chief Justice, I was also invited. I, the Governor, and the Vice President shared a table. Mr. Ansari was the President, the Vice President those days. So suddenly he asked me, Chief Justice, if I criticize the judgment of the court, would it amount to contempt? I said, Ansari sir, it all depends on who is the judge who is hearing the case. Insofar as I am concerned, I will not consider it contempt. And then incidentally, I mentioned about this Derezovich's book. Then he said, do you have that book? Of course, I may be prosecuted, but I had a photocopied version in violation of the copyright because the book was not available. I got it photocopied somewhere. I passed it on to Mr. Ansari. A few months later, it came back with a profuse thanking letter. The point is, because this is even a man who was holding that position as vice president, at least those days, he was worried whether it constitutes something, if I say something against the court, would it constitute contempt? It's not a very good thing. We have the other extreme. The other gentleman who laid down the office the other day went hammer and tongs about Justice Padivara's judgment in Tamil Nadu governor's case. They're both extremes. No, but point is, debate is there. So long if we are Democrats, we can't stop debate. Now, how to handle now, one possible is where facts are distorted, perhaps action should be initiated. That's what I believe. I may be right or wrong. It's for you people to, at least for those who are wielding the contempt power, to decide whether when facts are distorted, if facts are not true, then that causes more damage. And nowadays, a lot of dangerous situations emerge out of misquoted facts. Facts can be manipulated to suit a convenient narrative, which can create all kinds of problems all over the country. In fact, if I'm not guilty of making too many references to textbooks, there was 15 years back it came. There's a book titled 21 Lessons from the 21st Century for the 21st Century. Noah Harari. He gives an interesting, not interesting, a very sad this thing. Sometime in the 11th century, a young boy's dead body was found floating in a well in a small town called Lincoln in England. And the rumor mill was that this boy was killed in a sacrificial ritual by the Jews, which led to a program, and a number of Jews in the town were killed. And of course, Noah Harari, in his own immutable style, says, even in the absence of WhatsApp and internet, the news spread far and wide in Europe. And all over Europe, Jews were hunted. And then the story goes further. Over a period of time, the sainthood was conferred on the boy, and the boy was supposed to be performing miracles from his thing. And then after the Holocaust, finally the church issued a statement that there was no factual basis for the belief that he was killed by a ritual sacrifice. And then Noah Harari concludes, some falsehood lasts only 6 centuries, he says, because that is the strength of false statements. So God always guard ourselves against that kind of a thing. That's one area clearly where facts are distorted in a debate. Perhaps some action is required. And I think, whether I think 45 minutes is good enough, I suppose. I think I'll rest here. Maybe we can discuss something if somebody is interested in discussing further.
A few questions, if it's
Sure.
okay with you.
Sure.
Thank you, Justice Chelameswar, for the
Yes.
deeply enlightening address. Now, before we proceed to the question answer session, I invite the viewers who have joined us live to post their questions in the chat. But before we proceed to the question answer session, allow me the privilege of briefly introducing our Honorable Shri Justice Jasti Chelameswar,
Oh, good.
former judge of the Supreme Court of India.
Oh, not necessary, I think. Avoidable. You said former judge of Supreme Court, that's enough description. Leave it there.
Yes, I wanted to add that this is in fact a homecoming for Your Lordship
Thank
to
you.
the Kerala High
Thank you.
Court.
Thank you.
Yes, we will then move on to the question answer session.
Please.
Yes. Now, the first question is regarding the right to be forgotten. In the context of an acquittal, the legal principle of innocent until proven guilty is upheld, but the media tarnished reputation remains. Should Indian jurisprudence develop a more robust framework for the right to be forgotten or expungement of digital records for the acquitted, similar to some European models? We do have a division bench judgment on the right to be forgotten, but it carves a distinction for matters of criminal nature, weighing the right of the public to know about such matters. That is the first question, sir.
Yeah, maybe some mechanism could be developed. See, a person can't be hunted throughout his life. See, the very concept of atrofy acquittal in criminal law is based on that principle, I suppose. Once tried and acquitted, a second trial is not permissible. What is the reason? You can't harass him. Maybe he was guilty, but the legal process was not able to catch him up for various reasons. Defective investigating procedures or simple lack of evidence. Most often, what happens, I have seen, witnesses don't come forward for their own reasons, either of fear or XYZ reasons. People don't come forward to give evidence in a criminal case, especially in certain areas of my own home state. I know witnesses don't turn up at all. Then invariably, what happens is the police people try to plant witnesses. Of course, time is short. Otherwise, I can give a hilarious example of one of those cases which I heard in this. Want me to give the story?
Yes, sir, please.
Text
please.
time?
Yes, sir, please, please.
Okay. It was a case which I heard sitting in a division bench with another colleague. I was presiding. Some young man, some 25, 30-year-old young man, he was a sarpanch of a village. He was killed around 12 midday in a nearby town, the divisional headquarters of a district called Nambiar, otherwise very famous. It was Nambiar was a constituency from which late Mr. P.V. Narasimha Rao got elected those days when he became the prime minister. In Nambiar town, in front of the bus stand, this man was hacked to death by 3 or 4 assailants. And those are areas where nobody would come forward to give it. Even if you see, nobody would come forward to give evidence because they have their own problems there, faction fights and things like that. Now, finally, what did the prosecution do? 3 witnesses were brought. Who are they? The father of the deceased, the brother of the deceased, and a nephew of the deceased, 3 witnesses. Both father and brother were presented before the court to speak to the fact that they had witnessed the actual hacking by the accused. The nephew was produced to show that the father of the deceased was present in Nandyal town at that point of time. It all happened like this. Now the brother was asked in the cross-examination, so why were you there? Because it's a chance witness, he doesn't belong to that place. Then this fellow said, I came to purchase menus in town, therefore I was there. Next question, naturally, any competent criminal lawyer would ask, where is the proof of your purchasing the menus? He said, I didn't purchase the menus. Then next question, why did you not, having come all the way, why did you not purchase? Because when I went to purchase, Jaysankaran Nambiar was there. He told me, you idiot, did you not watch the TV last night? They said next 3 months there's not going to be any rain. Why are you wasting your money on purchasing menus? Therefore, I didn't purchase, was the explanation. Gone. Anyway, brother, you understand what value that kind of a witness. Second is the father. He was asked, he was also chance witness. He doesn't belong to that place. They belong to the next one. So why are you here? And this old man said, one of my daughters lives in this town. After both my sons left the village in the morning, I got a telephone call that my daughter who was living in this town was not well. Therefore, I came to see her. A probable explanation. But what really destroyed the case was the grandson, that is the nephew of the deceased. So this boy was examined. What was his case? It was a genuine case. He belonged to another village. He was also a chance witness, but he was coming to the town every day for some computer training course. Every morning he comes and goes through the training course and goes home. He was there that day. I was returning at the bus stand. I saw my grandfather. So this witness is there only to strengthen the evidence of the old man that he was present there physically just for that purpose. But then the defense lawyer, sharp man, said, then he asked the question, did the grandfather tell you that your aunt is not well and therefore has come? This boy said no. It's the most unnatural conduct. If the old man has come all the way to see his daughter, this boy happens to be another daughter's son. You would normal course say, look here, your aunt is not well, I'm going to see her, come here. I suppose that's the normal human conduct. This boy said, he never informed me. On the face of it, the trial court, of course, convicted them. We recorded a finding of acquittal. Next morning papers, what is the news? Broad daylight, people are killed, but High Court acquitted them. A very convenient statement. So what do I do as a lawyer? If you are running a kata panchayat, well, of course, these people can be sent to jail. See, these are the problems. The system has its own inherent problems, which gives scope for any amount of discussion. And naturally, the emotional surges will be there in people, especially in criminal cases, when something like this happens. So anyway, so therefore, so long as the facts are not distorted, well, you have to accept all these things. Yes. Yes, ma'am. Young lady, I hope did I answer your question?
Yes, my lord. Justice Nambiar, would your lordship like to add something to this?
Yes, actually, it is interesting, Justice Chelameswar, that you mentioned that last example, because this was one of the problems we found when we were dealing with cases on the criminal side. Thanks to the advent of the media and now social media, what happens during a criminal investigation, for example, as soon as a murder is committed and the investigating authorities have managed to, locate or arrest somebody in connection with that, the next thing that happens is that Section 27 recoveries. So, based on a confession statement, that portion under Section 27, which leads to the Kotaya versus Emperor. So now the entire exercise of Pulikota, Kotaya and Emperor is now videographed. So you have a stream of people accompanying this accused and the investigating agencies to this place. What the public sees, therefore, and reads in the next day's newspapers, complete with graphic details about, with arrows and, pictorial representation, is that there is a person who's supposedly the killer, who takes the police and the investigating agencies to the precise spot where he has hidden the weapon that he used for the killing and handing it over to the police. And the police then wraps it all up and draws up a marser, etc., and goes. Now, imagine what happens to a trial court that is deciding this on the basis of principles of evidence, where all this evidence has to be, this confession statement doesn't come in. Only that portion which leads to the recovery is taken as evidence. You still have to, go by the circumstantial evidence if there's no eyewitness. You still have to go by circumstances that point to unerringly to the accused. All of this is not established in the trial. So, like you mentioned, the trial judge, acquits him. And then the people are saying, what on earth is happening to the judicial system? Because you have a killer who confesses to everything. He takes the
There's a dead body staring at all of us.
Exactly. So this is very much a issue. That is what prompted us to actually mention this case scenario in our judgment, the larger bench judgment that Tushara was talking about. And we actually said that, when it comes to, the long and short of it is that I think the solution to this is basically self-regulation, whether it is that of the judiciary or whether it is that of the press. You need to understand that, judiciary, as you rightly said, there are certain areas which is a complete no-go as far as the judiciary is concerned. The Americans have recognized this by their neutrality principle when it comes to, aspects of religion and state and things like that. Similarly, we must also develop in our jurisprudence a neutrality principle which prevents courts from entering into areas which it cannot or it is not competent based on the craft of law.
It can't manage. We can't say
it can't manage, exactly. It's a more practical approach. Likewise, the press must also have some kind of a constitutional morality, in the sense it must understand that the judiciary functions on public faith. And therefore, when it comes to reporting...
And evidence. Hard evidence.
And evidence.
That they ignore. If nobody comes forward to give evidence, nothing can happen.
They make it very clear to the public as to, what can be reported, what is the truth and what holds up as evidence in a court. And that much they have to do. Otherwise, if they just give one side of the picture without saying that, this cannot be admissible in evidence, I think that's basically a misreporting and dissemination of false information. So, my takeaway from your discussion was basically that the solution to this problem may not lie in contempt jurisdiction or any other coercive steps. It would largely be resolved by self-regulation by both the parties.
And improved efficiency of the system.
Exactly.
Which improves the improved efficiency of the investigating agencies. Somebody must be held responsible in this kind of a shabby investigation.
Correct.
Somebody must be held responsible. Unfortunately, that process has not yet started.
Yeah.
Thank you, Justices. The second question, I believe that has partly been answered in this, but it is also quite the controversial question. Considering the increasing participation of advocates and retired justices in commenting on sub judice matters, should there be a stronger ethical statutory accountability mechanism?
Brother, would you like to answer or you want me to answer? See, the age-old principle is matters which are sub judice are not to be debated in public. It's not that a well-trained judge, as Lord Denning put it, will never be influenced by these debates. But question is, in a country where you have 1,000 judges of the constitutional courts and a few thousands of judges in various other levels, not all of them are of the same level of composure. Some people get rattled by adverse criticism, and then these possibilities are there. Therefore, matters which are sub judice, perhaps as a class, may not be permitted to be debated in public. Now, after the decision is made, well, it's open for you to criticize the judgment because the reasons are given, good or bad reasons, you can dissect them and debate them. But while the trial is actually going on, more particularly, see, normally civil disputes, nobody is interested in a debate. When brothers fight for joint family property, which TV channel would hold a debate on that? It's criminal cases or issues of public importance. Otherwise, they don't bother about it. At least in criminal matters, I still remember, you remember that Arushi case, the kind of debate that went on and on and on. The whole country was made to believe that the parents are responsible for the whole thing. At least that was the effort. Eventually, the result was something else. So it adds to unnecessary complication of the case and also tremendous trauma to the parties involved in the matter, which perhaps is something which is required to be regulated. But who will regulate is the question. Is it the legislature who is going to do it, or the constitutional courts who are going to do it? And it's a matter for debate, a larger debate, and maybe all the stakeholders should take a call on that. And insofar as this kind of a debate is concerned, one incidental statement you made, retired judges participating, sub judice matters certainly is not right. Especially retired judges, because it lends some credibility to the, by virtue of the very office which these people held. And they make a statement. There are a lot of people who are, of course, maybe there are equally good number of people who say, look here, this man doesn't know anything. Well, that's also possible. But then there's a possibility of some people believing because the judge is saying so, it is so. So therefore, it's wise and good for the retired judges to not to participate in these debates. Sub judice matters. Other matters is their choice. See, look here, for the last 8 years after my retirement, almost every 2 weeks, some journalists, I said, I'm very choosy about it. I choose certain where I think my view is necessary or I believe it is necessary. I do enter, but otherwise every day there will be somebody after me. They have been after me for the last 8 years. That's not right. Sorry.
Thank you, Justice. Now, this is the last question. I'm reading it out from the YouTube comment. Hello, sir. This is K.S. Sudhi, the Chief Bureau of the Hindu Kochi. I was hoping to hear from you on the recent judgment of the Supreme Court in the Omar Khalid bail plea. This was one judgment that was widely criticized by the national media.
Well,
That is the question.
Kalesh wrote a whole article and he forwarded it to me. I don't know whether you people have seen it or not. I got it. No, look here, this is the problem. The example which I gave of Mr. Parasaran's this thing, well, I had this article in my mind. I didn't want, since it's a current this thing, I didn't want to mention the name. Well, there's exactly the problem. If there is no consistency in the adjudication, it is bound to be controversial. People draw all kinds of inferences, some justified, some unjustified. Maybe we don't know. I don't want to comment about the matter, which is still, the man is still in jail. I don't want to comment about it. But then people are already debating it. And then the institution has given scope for that by those apparently conflicting orders from time to time in different cases, which is certainly avoidable. Consistency is the most important thing in law, which the ultimate credibility of the institution depends on the consistency. In fact, I recollect Sandra Connors in that Planned Parenthood matter, 1993 or 94. You remember, brother, the judgment, the abortion case, second abortion case?
Sandra Day O'Connor.
She was a member.
Planned Parenthood.
Planned
versus
Parenthood.
Casey.
First one was Roe versus Wade. This was the Planned Parenthood.
This is Planned Parenthood versus Casey.
Casey. In fact, when the invitation in that case is to overrule Roe versus Wade, lock, stock, and barrel, then she made a very wonderful observation. A change in the law on no firmer ground than a change in the composition of the court would lead to a popular misconception that this branch of governance in America is no different from the other two branches, she said. That's it. So because we've got to be very careful, because our only strength is our credibility, institution's strength. And the credibility comes from what good, sound jurisprudential reasons we give for each judgment we render. If we start issuing orders without proper reasoning and jurisprudential foundation, they're bound to be controversial. Yes, lady. Anything else?
Justice Nambiar, would you like to add something?
No. I just wanted to add a caveat to this whole discussion regarding what amounts to a precedent and are we being inconsistent? Because when you're talking about constitutional adjudication, this is something that has always troubled me in courts. When you talk about constitutional adjudication, you do have situations where a particular principle of interpretation or a provision or an ideal of the Constitution that is interpreted by the Supreme Court in a particular way, maybe in the 1960s or 70s, ceases to hold the field because of changes noticed in society between 1960, 70 and then, in the modern day. So there may be a change in the understanding or perceptions in society over a period of time, in which case the interpretation itself of that particular concept would be different in the changed circumstances. And in those situations, you don't say that there is an inconsistency between the stand taken by the Supreme Court. It's basically an evolution of the law. So I just didn't want the viewers to confuse between inconsistency and evolution of the law. The evolution of the law must happen.
Yes.
For example, the privacy concept itself, which we actually abandoned after consideration when the Constitution was enacted. We subsequently introduced it through case laws and through interpretation of the very same article, Article 21, in Puttaswamy. So that was an evolution of the law, but initial was an abandonment of that concept in the Constitution.
Brother, if you can always take a different view, provided you are willing to support it with proper legal reasoning.
Exactly.
That's all. But he says you just stick to some archaic principle.
Correct.
And for eternity. If there is a change circumstance, but provided you are willing to give the solid reasons for the change in the view. You recollect Robert Bork, man who was nominated to the Supreme Court by Reagan. The nomination didn't go through. He withdrew at some stage because the heat was too much. It's a brilliant mind. The opposition to him was that he was ultra-conservative, he was not incompetent man or
He's written that famous book.
A famous book, Tempting of America and Political Seduction of Law. That is the title. Now, what he says is, I am dubbed as a conservative. See, Brown versus Board of Education was decided on the basis what would be the psychological impact on the mind of a child who is made to go through this segregated school system. But later, segregated beaches, restaurants, for all those things, simply Brown was quoted. That logic, maybe they can be justified for different reasons, the conclusions. But then without giving the supporting logic, simply quote Brown was the Board of Education and right. That's what he was criticizing, for which he was dubbed as an ultra-conservative.
Yeah.
That's it.
Thank you, Honorable Mr. Justice Chelameswar and Honorable Dr. Justice Jaysankaran Nambiar, sir. To formally conclude today's program, I now invite Advocate Ramola, Advocate, High Court of Kerala, to deliver the concluding remarks.
Thank you, Tushara. I think we can all agree that we have concluded a truly intellectually stimulating session, especially drawing from the vast experience that both of our distinguished judges have had. I think basis the discussion that we've had, or at least the key takeaways that I have drawn from this discussion, is that at the essence of this apparent conflict, say between the right to fair trial and the right for the media and their Article 19 rights. I think at its very essence, self-regulation is the answer. As Justice Chelameswar rightly said, I think improving the quality of engagement, not just of adjudication as far as judges and members of the bar are concerned. I think also civil society being responsible with how they engage with the law, be it decided cases, be it with the evolution that those cases see through the passage of time, as Justice Nambiar had stated. I think it is all about how one engages with what they consume. And as Justice Chelameswar had said, with the advent of the internet, our opinion once out there can never come back. It's out there almost forever. So I think it is very important that all of us involved in the system regulate ourselves so that the dignity and the credibility of the system is not brought down.
And
The other thing which I'm sorry, sir.
And just to add a little this thing, the opinion once out, the radio waves remain in the universe for eternity.
Exactly.
Maybe the intensity gets maybe diluted. Okay, but then for eternity, the radio waves remain.
Exactly. So, which is why I think it comes back to what Justice Nambiar had said, where I think we should regulate how we engage, because once it's there, then that's how you are known, and it can probably either dissipate. And like you said, so you got a message, you don't know who authored it. So, but that opinion is out there now for everyone to consume. And I think the second thing, which Justice Chelameswar had rightly said, is that while discussions and debates are inevitable, I think it would be helpful to have sub judice matters specifically excluded or preferably excluded from being debated far too much in any form of media. And this is especially so because while, as Justice Chelameswar had said, facts are sacred, but opinion is free. The sanctity of those facts, I think, with more and more debate, can be distorted at some level. So I think, as rightly stated, there must be some form of regulatory framework. As we're not sure how that will actually translate, but definitely there must be some form of regulatory framework stopping discussions on sub judice matters because there is a risk of distorting facts. And lastly, I think, as both the judges have rightly stated, the contempt jurisdiction does not appear to be the answer. But what the answer is also will require all the stakeholders to come together and formulate so that there is ease of understanding for both the bar, the bench, and the media on where their respective zones end. So I think with these reflections that we have drawn from our very fruitful discussion, it now falls upon me to perform the very pleasant duty of proposing the vote of thanks. And sir, unless you have something more to add, of course.
No, I just wanted one sentence. There's a famous anecdote, when Lord Cromwell was the protector, some scurrilous pamphlet was circulated against him. One of his friends brought it to his notice and said action should be initiated. He made a very profound statement. If my government is here to stand, I have nothing to worry about a paper shot. Let him have the paper, I'll have my government, he said. It applies equally to the judiciary. So long as your foundations are strong, don't bother about it.
Absolutely.
That's for my brother, this part of it, as an elder brother.
Absolutely. So first and foremost, sir, on behalf of the Indian Law Institute and of the Kerala State Unit, I extend our most profound gratitude to you, sir, for having graced our virtual podium despite your ill health. We are most grateful for that. Your discourse has been, I think, a masterclass drawing from your extensive experience, both on the bar and the bench. And I feel you have rightly stated the delicate equilibrium that needs to be maintained between the freedom of the press and the sanctity of judicial independence. So I'm so very, very grateful for you to have so easily explained such a complex topic to all of us. Very grateful for that.
Thank you.
I also want to extend our heartfelt thanks to Honorable Dr. Justice Jaysankaran Nambiar As everybody knows, he is our executive chairman. Your lordship has been the guiding force for all of our functions, especially this event. Thank you, sir. You've very thought-provokingly set the tone through your introductory remarks, and you have very aptly also given your contributions to all the questions that have been raised. So we are truly thankful to you, sir. Next, I would also like to thank the President and Secretary of the Kerala High Court Advocates Association, who have always helped and supported the ILI Kerala State Unit, and they have also participated extensively in this session. So I'm very grateful to them. And lastly, I'd also like to thank the journalists and the media professionals who have joined us today. As Tushara had rightly read out a very relevant question that was raised by one of the media personnel, which I feel helps that this engagement in this dialogue is very vital from their side as well. So I'm very, I appreciate their participation in this function. And finally, of course, all the advocates, the law students, and the other distinguished guests who have tuned in on this live YouTube at such a late hour, despite their busy schedules. I'm very, very grateful. Thank you all. Jai Hind.